Pretrial, July 2006. Next witness, the clerk. Please raise your right hand. Lieutenant John Byrnes, called as witness herein, having been first duly sworn, was examined and testified as to the following. The clerk. Please be seated. Please state your name and spell your last name for the record. The witness. John Byrnes, B-Y-R-N-E-S. Direct examination by Attorney Strang. Mr. Byrnes, tell us just a little bit about how you're presently employed. I'm a jail administrator for the Calumet County Jail. That's my present position. All right, jail administrator, meaning you have general responsibility for all facets of the operation of the Calumet County Jail. That's correct. You report directly to Sheriff Poggle? Yes. But anyone who actually works in the jail reports to you? Correct. In addition to being a jail administrator, you remain a sworn officer of the Calumet County Sheriff's Department? Yes. Is that department you presently hold the rank of lieutenant? Correct. Yes. How long have you been in the position of the jail administrator of Calumet County? It's been 4 years. Continuously? Yes. So for the period, let's say November 9, 2005 through the end of December 2005, you're the jail administrator? Correct. Did you bring with you today any documents? Yes. For reading the subpoena, I brought a copy of the visitation policy that's been used by the jail. Thank you. May I have that? Sure. Thank you very much. I've got several questions about this. You have given me 3 pages stapled together, but the first 2 are two-sided. That is, there is typing on both sides. Yes. All right. There is an excerpt out of the larger book of jail duty, jail rules and regulations. Yes. But these are all the rules relating to visitation. Yes. These rules were in effect in this form during the period November and December of 2005. Yes. For ease of reference, that's the time frame I'm going to use here, that 61 days here unless I tell you otherwise. All right? Okay. Did you bring more than one copy today? No, that's the only copy I have. All right, I'm going to give this back to you. I think I will do this mark as an exhibit. Is your honor's preference that we just mark exhibits sequentially or separate? The court. Yes. Exhibit 7 marked for identification. I want to be careful about this, Mr. Byrnes, because although I accept what you said, that these rules were unchanged and they were in effect as you have been given them to me in Exhibit 7 in November and December of 2005, the last page looks to me like it says was approved on March 24th, 2006. That's correct. Many of the policies that I personally work on, I set them for annual review, and I take a look at the policy, determine if there needs to be any changes. When I checked my history document, the previous change to the visitation policy was made in 2003. So this policy, although it was examined and reviewed within the past year, it was unchanged. Great, thank you. Sure. Attorney Strang, now I will offer Exhibit 7 with that explanation. The court, any objection? Attorney Kratz, none. The court, Exhibit 7 is received. Attorney Fallon, no objection. By Attorney Strang, very quickly introduce the court, if you would, to the command structure within the Calumet County Jail during the time frame we're interested in. The head of the department, of course, is the sheriff. I report to Captain Paul Rush, and underneath me would be 1 sergeant and then our corrections officers. Attorney Strang, should we push the mic just a little bit closer to the lieutenant? By Attorney Strang, so when you say 1 sergeant, there's not 1 per shift, there's only 1 sergeant of the jail? 1 position, yes. Okay, and that's a daytime position? Yes, daytime evening generally works 9:30 a.m. until 5 p.m. And your general hours are what? 6 a.m. to 2 p.m. Okay, so he is then in charge of the jail from 2 to 5:30, roughly? Correct. Overnight, what's the authority structure from, 5:30 p.m. to 6 a.m. when you come back? There's just correction officers on duty, and if there would be an issue, they would report to the patrol supervisor. Between the hours of 9:30 in the morning and 5:30 in the afternoon, again, during the time period of interest, what's the total staff complement of the Calumet County Jail? It can vary, generally on a weekday. Myself, the sergeant, and at least 2 jailers, corrections officers would be on duty, and perhaps a third. We may also have transport officers. They generally work under the sergeant and I, so we may have transport officers working. Transport officers in the Calumet County are temporary duty employees. Correct. They don't report to work unless requested on a particular day at a particular time. Correct. So the actual staff of the jail would be either 4 or 5 from 9:30 in the morning until 5:30 in the afternoon. Yes. When one comes to what I think of as a reception window near the little historical display in the lobby, yes, those people, although they wear uniforms, they are not jail staff. Yeah, the window on the right is clerical staff. For the sheriff's department? For the sheriff's department, yes. Not attached to the jail per se. One of the clerical staff is attached half-time to the jail. Fair enough. The 9:30 a.m. to 5:30 p.m. staffing complement that you have described is the same or different on the weekends during this time period. On the weekends, it would just be corrections officers. 2 or 3 people on duty? Correct. And no transport officers on the weekend. Generally not, unless they are called in. You have original of Exhibit 7 in front of you. Yes, I do. Okay, the Calumet County Jail, again, all of my questions are going to be during that time frame I have described. Calumet County Jail controls access to inmates. True? True. Almost obviously, members of the public do not have access to inmates other than on terms under the control of yourself and the people working for you in the jail. Correct. When I say members of the public, that would include lawyers and inmates. Include lawyers for inmates. Yes. Religious advisors or chaplains, that type of thing, who may wish to see inmates? Yes. Alcoholics Anonymous counselors, those kinds of people? Yes. Family members? Yes. Friends of the inmate? Yes. And even law enforcement officers? Yes. They would gain access to an inmate in the jail, that is, law enforcement officers would through you or your corrections staff. Correct. That said, there are different rules that apply to some of these different groups I have described. Correct? Yes. Let's start with lawyers and clergy members. And I think we can group in probation and parole agents there as well. Correct? Yes. There's specific rules that apply to 3 groups I have just described. Yes. Their access will be permitted to the inmate for lawyers, clergy members, probation and parole agents during reasonable hours. Yes. You ultimately decide what those reasonable hours are. Yes. Reasonable hours would not include during shift changes. Correct. It would not include when you are trying to serve meals. Correct. That is, you as jail administrator are responsible for the care, feeding, and safekeeping of inmates in your custody. Yes. Moving visitors or dealing with visitors distracts from or requires manpower, I guess, would put it another way, right? Yes. So at critical times, like a shift change, when one would be leaving and another would be coming in, it's not reasonable to expect changing shifts also to juggle professional visitors. Generally not. If a visit was started prior to a shift change, they may allow it to continue. but probably not to terminate, requiring movements of the visitors out and the inmates back to their cell during the shift change? Correct. Same with meal times? Yes. Not might allow the inmate to continue a visit through the meal, and maybe you would hold the meal for him, correct? Yes. But you aren't going to doing an inmate movement or visitor movement during the actual process of feeding. Generally not. Again, if it's important to move an inmate, they will hold a meal. It really depends on the situation. And quiet is a reasonableness, as I understand the rule? Yes. So we're talking of generally the visitors, even professional visitors, we have described, would avoid meal times and shift changes. If we can, yes. Other than that, do you expect advance notice from, let's say, an inmate's lawyer? We prefer it, but again, we understand schedules, and yeah, sometimes they drop in and we do our best. You try to accommodate. Yes. But again, it's a rule of reason. Yes. All right, law enforcement officers are not covered specifically in the terms of their visits with inmates and these rules, Exhibit 7, correct? I don't believe so. There again, though, law enforcement officer would have to contact you or someone working for you to arrange a visit. Yes. Lawyers, probation agents, clergy members are allowed to what's called a contact visit. In most cases, yes. And Exhibit 7 refers to a little bit obliquely in paragraph, what is it? Sorry, 29.00.30, subsection G, as in golf, right? By identifying the two visiting rooms that may be used by clergy, lawyers, and probation agents. Yes, those are what's called contact visit rooms. Correct. By contact visit, there is no barriers separating the inmate from the visitor. Correct. No need to use a telephone to speak through the barrier. Correct. Law enforcement officers are also permitted contact visits? Yes. Law enforcement officers can also visit at any reasonable hour? Yes. Their visits can last for a reasonable duration? Correct. So, in many ways, they are treated much like lawyer, the clergy member, or probation agent. Yes. When we step away from law enforcement officers, the inmates, lawyers, clergy members, and probation agents supervising the inmate, and we get into family members, friends of the inmate, the rules are different. Yes. There are more rules. There are structured hours that they can visit, yes, and rules limiting the amount of friends that can visit. Rules limiting the length of the visit? Yes. In the case of your jail, to 20 minutes? Yes. There's no limit on time, the length of a lawyer's visit or clergy member visit, other than reasonableness. Again, correct. So you've got this. You've got the visiting schedule for friends and family members set up Thursday and Sunday evenings. Yes. Females from a certain time, male inmates another time. Yes. These are not contact visits. No. At least ordinarily. Yes. Ordinarily, it's a non-contact visit through the phone and a glass barrier, reinforced glass barrier. Yes. Okay. These visits routinely are tape recorded by the jail. Yes. Contact visits are or are not tape recorded by the jail. Not. Just not at all? No, there is no recording device I'm aware of in there. Okay, and you would know. I would hope to. Okay, further, the inmate who wishes to have family or friends visit must complete a visitor list. A visitor list. Yes. Within the jail. Yes. There is a limit on how many names can be on that visitor list. 3. And those can be changed. One name can be substituted for another. Yes, we allow that on occasion. Right. There again, not willy-nilly, whatever the inmate wants. Yes. I'm seeing these for the first time, but I also take it that visits by people other than lawyers, clergy member, and law enforcement officers or probation agents require an identification procedure for the visitor. Yes, family or friends or most anybody we prefer to see identification, especially if we don't know the person. Sure, okay. And now again, setting aside the four groups, the professionals, so to speak, that I have been talking about with family members and friend visitors, what is the identification procedure? We request a picture ID if we don't know the person. The information is recorded, and if the visit is allowed, generally there's a check done to make sure there's no wants or warrants for the person. Right. Is a criminal record check done as well, just to see if there are open wants or commitment warrants? Generally, there's just a basic wants check. All right. So when that person, the visitor, is in law enforcement, and if somebody is wanted by a law enforcement agency, you wouldn't want them to walk in and out unmolested and be out there with an open warrant. Correct. The general visitor may not bring recording equipment into the jail for the visit. No. The general visitor, the father, the mother, the wife, whomever, can't bring in a camera for the visit. We try to limit personal property to a purse, but I don't know that we specify cameras. I would request they don't. I would request that they don't bring a camera. Sure, and you would have the ability then to prevent that person from entering with a camera. Yes, you would have to leave it out there or that kind of thing, or leave it in your car. Correct. So there's some screening of the visitors in terms of what he or she is carrying with him. Correct. Primarily because the room is small and there can be up to 8 people, in a room or more. So, right. Primarily just for that reason. Fair enough. Are there any rules in Exhibit 7 that address members of the media in specific? No. Do you have any other rules, written or unwritten, that apply generally with respect to visits by reporters, members of the media? No. You're familiar with Mr. Avery, two chairs to my right? Yes. He is currently an inmate of your jail? Correct. He has been since November 9th, 2005? Yes. Other than for a brief time with hospitalization and a transfer to the Brown County Jail, he's been continuously in your custody since that time? Yes. Exhibits 8 and 9 marked for identification. You can just drop 7 there, and I will give you Exhibit 8 and 9. Do you recognize those? Yes. What's number 8? Number 8 it's a copy of 2 separate forms. The first one is the Fifth Amendment rights invoked, indicating that Stephen has invoked his Fifth Amendment rights and that he's requesting an attorney to be present during questioning, and that was signed by Corrections Officer Hansel on 11/9/2005. Hansel, Hansel? Correct. First name Noel? Noel, yes. And the bottom is the notification of victim form. If a person is released from jail and there's a victim or somebody involved in the case that needs to be notified, this form is to alert the corrections officers to do that. Both of those forms then are copied together on Exhibit 8 or Calumet County jail forms? Correct. They normally would be found in the inmate's file. Those were stapled to the front of the file. Routinely? Yes. Those 2 forms are on the front of the file, so they are very prominent. In Mr. Avery's case, as in one case every other inmate? Correct. There is a unique file created or a single file created for every inmate for any duration in the jail. There is a paper file created, yes. All right, so Exhibit 8 goes on the front and both of them stapled to the front to be prominent. Yes. And number 9, what is that? It's a note written by Stephen Avery. It indicates that he does not want to talk with any reporters from any news media. This includes TV, newspaper, radio, internet, magazines, or any other media. Is that dated, Mr. Byrne? It's dated November 12th, 2005. When did you first see it? I believe I first saw it when I copied the contents of the folder for you a couple of weeks ago. Okay, you found it in the inmate file for Mr. Avery? Yes. That file is available to all the corrections officer staff you have described for us. Yes. Do you not routinely look at the inmate's file as the jail administrator? On occasion, yes, I will. Maybe we have gone past each other. I ask you, do you not routinely do that? I don't make a habit, but generally handle most of the files. Okay, so how is it that you first saw this Exhibit 9 when you set out to copy the Avery file for me? I guess what confuses me a little bit with this exhibit, if I would have seen it, or believe if a sergeant would have seen it, it would have been date stamped, and it's not date stamped. So I'm not sure when I saw it. I may have seen it before, but I don't recall reading it. And the question is, why would you not have seen it until I asked you to copy Mr. Avery's file for this hearing? It was probably given to the corrections officers. The corrections officers may have noted it in the jail log and then placed this in the file. You found it in the place it should be, correct? Yes. I mean, the correct place for the Exhibit 9 to have been filed is in the inmate's file. Yes. Where you found it? Yes. You have no reason to think that one of the corrections officers hid it or misfiled it or did anything mistaken or improper with it. No. You just not had looked for it. I didn't recall reading it until I viewed it and made you a copy. Fair enough. And I guess if I'm hearing you, you may have read it earlier. You just don't recall. Yes. Have you talked to your jail sergeant about whether he or she was familiar with it? No, I did not. Have you had a conversation with anyone at all about Exhibit 9 before today? No. Attorney String, I will offer Exhibit 9, 8 and 9, Your Honor. The court, any objections? Attorney Fallon, no objection. The court, Exhibits 8 and 9 are admitted. Attorney String. Mr. Byrne, you're aware of the 3 televised interviews that occurred in Calumet County Jail involving Mr. Avery during the November and December of 2005. Yes. Are you aware of any more than that televised interviews now that I'm speaking of it? No. The first of those would have been on November 12th with Emily Matesic of Channel 2 out of Green Bay. Yes, I believe so. Was the second November 18th Jennifer Cobas, Channel 5 out of Green Bay? Yes. And the third was Miss Cobas, again, December 14th. Does that sound right? I would agree. That sounds right. Okay, when did you first have contact of any kind with Emily Matesic? I'm not sure I did. Ever? No, I'm just not sure that I did. Wouldn't know if she walked in the room? Well, I believe I saw her when she testified and did not look familiar. Okay, when did you first have contact at all with Jennifer Cobas? I'm not sure if I spoke with her on the phone or she came to our lobby, but I was present when she did an interview with Mr. Avery. Do you know whether that was the first or second interview that she did? I believe it was her first. What caused you to be present in the lobby for that interview? I think she asked to speak with somebody in charge or explained that she wanted to be referred to me, and I went out and spoke with her. What did she tell you? She indicated that she wanted to conduct an interview with Mr. Avery and requested to see him. Your response? At that time, I requested that she write a note to Mr. Avery, and I indicated to her that I would show that to Mr. Avery, and he could make that decision. Was Jennifer Cobas on Mr. Avery's visitor list on November 18, 2005? No. Was she his lawyer? No. Was she a member of the clergy? No. She wasn't his probation agent? No. How about law enforcement? No. What provision of the jail rules or regulations might we look for suggesting somebody could appear in the lobby, write a letter to an inmate, and jail administrator would take the letter to the inmate. There's nothing in the policy. You took a letter to Mr. Avery personally? I believe I did, yes. All right. And what was your conversation with him? I just explained the situation, that there was a person from the media in the lobby requesting to see him. I handed him the note and waited for his reply. Exhibit 10 marked for identification by Attorney String. I show Exhibit 10. Now, that's just one page out of what I'm sure is a longer document, but maybe you recognize it. Yes, it's copies of our jail log entries. The date would be November 12, 2005. The first entry on this page was made at 9:17, and the last entry was at 19:33 hours. Thank you. Is Exhibit 10 something that is prepared by Calumet County jail staff in the ordinary course of their business duties? Yes. Is it prepared or at about the time of the events it reflects? As close as possible. Prepared by someone with the knowledge of the facts of the events that were entering in the comments line? Correct. And is it then maintained and kept in the ordinary course of business at the Calumet County Jail? Yes. Attorney String, I offer Exhibit 10. The court, any objections? Attorney Fallon, and Exhibit 10, which is just a one page or page 2. Attorney String, I just marked the one page as Exhibit 10. Attorney Fallon, I have no objection. The court, Exhibit 10 is admitted by Attorney String. Now, I want to go back to this first entry that you started describing to us as identifying Exhibit 10. There's a code number there, I see, and 801, and then for instance, in the next entry, I see number 700. Those refer to people, correct? That's correct. Who's number 801? 801 would be Sheriff Poggle. He's got ultimate responsibility for the Calumet County Jail. Correct. As well as for the Calumet County Sheriff's Department. Yes. And number 700, is that you, the jail administrator? Yes. All right, so November 12, 2005 at 9:17 going on 9:18 in the morning, somebody named Juckem, Juckem, I guess, receives a call from Sheriff Poggle, correct? Yes, that's the corrections officer, Denise Juckem. She's somebody who works for you as a corrections officer? Yes. So she's telling us that Sheriff Poggle called, and as he states, if the media want to interview Avery, we can allow them to do so, right? Yes. Avery refers to Stephen Avery? Yes. If Avery wants to talk to them, right? Correct. This can occur in the conference room in the jail, right? Yes. So we're going to make sure all the media logs in. Yes. Make sure we get the TV station, reporters, and camera person's name. Yes. Also, make a copy of their ID. Correct. All right. Were you aware that the direction from Sheriff Poggle the morning of November 12th? I believe so. I believe we had discussed that within the first couple of days that Stephen was in the jail. We were getting a lot of requests from media information and also to see him. And I did at one point approach the sheriff and ask him how he wanted to handle that. And what is written down is pretty much what we had discussed. Okay, do you remember if it was November 12th that you approached the sheriff about that? I believe it would have been before that, probably the 10th or the 11th. It was within the first couple of days that Stephen Avery was in the jail. Okay, and the next thing that Denise Juckem does, according to the log, Exhibit 10 is roughly 27 minutes after the phone call from Sheriff Poggle. She makes a 1021, which is just a call, right? Yes, a phone call. To you. Yes. And tells you that what Sheriff Poggle advised, right? Correct. And then she asks you questions about essentially how you want to move Mr. Avery back and forth for such a visit. Yes. And you tell her if we need extra help while the media is there, we can call someone in to assist with jail duties. Is that what you told her? Yes, generally, we do have 5 part-time people, and if they felt they needed help, I had told them they were free to call in some help. Now, November 10th, 12th, we have testimony here. I think it was a Saturday morning. I don't expect you to remember that, but I think it was a calendar will bear me out. So if you're going to have a call in to help on short notice on any day of the week, you're going to incur some extra costs at the jail, correct? Yes. Labor cost, right? Pardon me. Labor cost. Labor cost, yes. And if it's going to be a Saturday or Sunday, those costs may be higher still. No, the hourly rate is the hourly rate. They need a union, but essentially, if I understand you here, what you are telling the corrections officer is the checkbook is open. We'll pay extra labor costs if we need to accommodate the media if they want to see Mr. Avery. Attorney Fallon, objection, speculation as to the intent. The court, I will sustain the objection. Attorney Strang, did you put in any limits on how much extra help, how often, for how long, and on who say so? Not necessarily, but it's always been our policy in the jail that they are free to call in part-time staff person for any visiting time. So it's not unusual to allow them to do that. Well, let's talk about what's unusual. Prior to November 12, 2005, during your entire tenure as jail administrator of the Calumet County Jail, can you recall on one occasion in which a TV camera crew interviewed an inmate of the jail? Uh, I couldn't give a specific. No one comes to mind, not offhand. And how long have you been with the Calumet County Sheriff's Department? 27 years. In your 27 years as Calumet County Sheriff's Department, do you remember any other inmate? I don't need the name, but do you remember any other inmate who has attracted as much immediate attention as Stephen Avery? No. The next entry, now we have got a corrections officer named Conan, Konen. Yes. The next entry is at 10:16, roughly that's that same morning, November 12th. And we've got channel 2 calling, right? Yes. And who's number 714? That would be Denise Juckham. Attorney Strang, where's my second copy? Your Honor, I realize I'm leaving you in the dark. Attorney Fallon, never a good thing to do to a judge. The court, thank you. Attorney Strang, sure. May I share with you? May I share with you? The witness, sure. Attorney Strang, I gave my last copy to the judge. Attorney Strang, so you know some 30 minutes, not even, I guess, or 32 minutes after this discussion that you have here about how we're going to move Stephen Avery if the media wants to see him, lo and behold, we get a call from the media, at least according to Exhibit 10. We are getting a lot of calls. Okay, and Ms. Juckham or Officer Juckham and Officer Conan go back and at least according to this, they talked to Avery and asked him if he would speak to the media. Correct. And Avery stated, here they quote, yeah, for a second. Yes. Have you given instructions to the corrections officers on when used to quotations in a jail log, quotation marks? No. And your understanding, though, would be that the use of quotation marks connotes a verbatim statement from the person being quoted? Yes. That certainly would have you reply on this document in reading it. Yes. And then it looks like within 30 minutes, there's some further discussion between Officer Conan and now again Sheriff Ogle. I'm sorry, go ahead, you take it. 10:46 a.m. Yes. And at least what is it, Mr. Conan? Yes. Officer Conan? Yes. Todd says is that Sheriff Ogle advises corrections officers are to stand outside the conference room, not inside, when is being interviewed by the media. Yes. Did Sheriff Ogle explain to you at any time why he wanted officers standing outside the room? At that time, it was the first few days that he was in our jail, and due to what had been accused of, we wanted to be closed for security reasons. Yes. Okay, why have them outside the room, not inside the room, according to Sheriff Boggle? What did he tell you about that? I'm not sure he explained it, but generally, with all the professional visits, we don't stay in the room unless there's an immediate security concern. Sure, we allow the conversation in private. When a lawyer visits for professional visits, contact visits, it would not be the practice to have even one correction officer standing outside of the door, would it? No, let alone two. No. So this having two corrections officers outside the door was an improvised procedure here to be used with the media interviews of Mr. Avery. It was a decision based on everyone's safety. And that decision was Sheriff Poggle's? Yes. The interview room itself that was used here, are you are familiar with? Yes. It has what I would call a linoleum floor or tile floor. Correct. The hallway through which the visitor goes is the same linoleum tile. Correct. The hallway through which the inmate passes into the other door, the second door, is poured concrete floor. There's some sort of covering on it, but yeah, it's a hard surface. It's a hard surface. The two doors into this visiting room are heavy metal security doors. Yes. With security glass. Yes. They are not flush with the floors. No. That is, there's a gap of an inch or something under each of those doors. Probably, yes. One standing within a couple of feet of those doors can hear with relative ease what people are saying in the normal conversational tone inside the visiting room. It's not been my experience. I disagree. No. You could not hear if you're standing at the door what people are saying in a normal conversational tone in the interview room. I don't believe so. As I said, I did stand outside the door during one of the media interviews, and I couldn't hear the conversation at all. No, I may have heard some of it, some noise, but it wasn't to the point I could understand the words. Could you make out? Could you make out the words? Okay, correct. Fair enough. And yet, the privacy concerns, the not being overheard with lawyers or clergy visiting an inmate, cause you not to station someone near the door. Not so much a privacy concern with an attorney visit, it's primarily a security concern with the media, why we wanted someone close. With an attorney, there's generally not the concern about the attorney's safety. It's somebody that, in most cases, is someone that the inmate is looking forward to help them, so they are usually glad to see them. Okay, I don't disagree with that. Any reason to think that here Mr. Avery was not glad to see the media? No, but I have seen media at times. It depends on their approach. And not knowing Mr. Avery at that time, we didn't want to take the chance. You had a concern potentially that, or at least didn't want to take a chance on the safety of two people from the media. Correct. That is, he may not have been happy to see them, was your concern. He may not have been happy, or they may have done something to provoke him during the interview. I've done lots of things to provoke clients during interviews in jail, but I have never had a sheriff's deputy standing there for my safety. So what was the concerns about the media provoking Mr. Avery? I guess, as I said, we weren't sure. I'm familiar with Stephen Avery. We weren't sure what types of questions they would ask or what they would imply and what his reaction might be. Okay, because they are his professionals in a way that they felt that there was a duty to protect them. Okay, giving you back Exhibit 10, it was a busy day for Mr. Avery because a couple hours roughly after Emily Matesic and her cameraman leave, in comes Mr. Avery's lawyers, right? Correct. At 1:24 p.m. He meets with Mr. Avery? Correct. No corrections officers are stationed outside the doors for that meeting. I don't believe so. That would reflect it if it were. It probably would. And that's why the entry here concerning the note that Mr. Avery writes, it indicates the entry was made at 4:04 p.m. It should be noted that the above subject, Mr. Avery, they were referring to, wrote a note to the jail staff that he wishes not to speak with the media, newspapers, internet, etc., etc. All calls inquiring about the subject should be directed to his attorney, Eric Loy, per his note. Eric Loy is an assistant state public defender who's responsible for Manitowoc and Calumet counties? Yes, he was his attorney at that time. There's something you knew about at that time? Yes. That's something that your staff knew at that time? Yes. The jail log is maintained for access to you or access by you? Yes, I review it daily. Your jail sergeant reviews it daily? Yes. The corrections officers are expected to review it daily? Yes. That's an entry then that you would have seen on Monday, November 14th. Correct. You did see that entry on Monday, November 14th. I believe so, yes. You reviewed the jail log first thing in the mornings, correct, essentially. Yes. At any time after November 14th, 2005, are you aware of Mr. Avery submitting a contrary or overriding instructions to the jail about his preference with respect to contact with the media? Not that I'm aware of. You searched for his file carefully? Yes. You personally copied the contents of the entire Avery inmate file. Most of it. There were some private letters that I didn't forward to you. Private letters? I believe there were letters that were written to Mr. Avery that for some reason probably weren't delivered. They were denied for some reason, and I kept it in the file. Kept in the file. Yes. Okay, but you saw no document superseding the modifying Exhibit 9, which is in front of you. No. Exhibit 11 marked for identification. I show you Exhibit 11, which I believe to be the very next page of the jail log that you have described and that we marked as Exhibit 10. Correct. Attorney String, this is Exhibit 11, Your Honor. Attorney String, now we're back to Noel Hansel, who you told us about with respect to the invocation of Fifth Amendment rights. He makes an entry at, I think, just at 5 p.m. Does he not? 17:15. Okay, 5:15 p.m. 5:15, right? Yes. Why don't you, Attorney String, well, after I offer Exhibit 11 as well. Attorney Fallon, I have no objection. I'm confident I have no objection. I'm confident this is an accurate documents provided by the business records from the jail, so that's fine. The court, all right. Exhibit 11 is admitted. Attorney String, what's the entry from Mr. Hansel at 5:15 in the afternoon? Noel would be a female. I'm sorry, I apologize. That's all right. I will read the entry. At approximately 1700 hours, Owen Jensen, a reporter for NBC 26, was in the Sheriff's Department lobby. I talked with Jensen. Jensen requested an interview this evening with inmate Avery. I told Jensen that inmate Avery has refused, in writing, to speak with the media. I referred Jensen to the inmate Avery's attorney, Eric Loy, per inmate Avery's written request. Following the directions, or at least consistent with all directions set forth in Exhibit 9 by Mr. Avery, correct? Correct. Exhibit 12 marked for identification. Showing you Exhibit 12, yet another page from the same jail log. Correct. Prepared and maintained under the same circumstances. Yes. Attorney String. Offer Exhibit 12. Attorney Fallon. I have no objection. The court. Exhibit 12 is admitted. Attorney String. Let's look at the November 18, 2005 entry. You will recall that as that day we agreed that Jennifer Holbas for her first televised interview from the jail, right? Correct. Okay, and there's an entry there concerning Fox 11. Yes, at 9:50 a.m. The entry was made by Corrections Officer Cheryl Mason. I will read it. Mark Leland from Fox 11 called and wanted to give a message to above subject. To call to arrange for an interview. I gave the subject a message and refused to take it. Did not want to call. It stated that all inquiries will be forwarded to his attorney. I called Mark Leland back and advised him that Avery stated to and gave him Eric Loy's number. Now, the subject of the above subject referred there is Stephen Avery? Correct. So this time it appears that the correction officer rather than just turning away the inquiry, goes and asks Mr. Avery. Correct? Yes, and that is them in the procedure we had set up. But Mr. Avery's letters, Exhibit 9, clearly stated, I just don't want to talk to these people. Correct? Yes, but I guess as a corrections officer, the sheriff tells me I deliver the message. I would deliver the message. Was Sheriff Poggle involved? Well, he had the previous orders were to, if there was a message, give it to Mr. Avery. Okay. Do you know whether Sheriff Poggle reviews inmates' files at the jail? On occasion, I have seen him in the jail office. Reviewing an inmate file? Possibly. I'm not sure. Does he review the jail log, exhibits 10, 11, and 12, that document regularly? That I couldn't answer. One way or the other, I couldn't answer. Is it available to him? This is available on computer terminal. It should be available to him. But in any event, Avery refuses Fox 11 and says, tell them to call my lawyer, or words to that effect. Correct. What's the next entry relating to Mr. Avery after that? And that's at, I don't know, something that morning? Yeah, 9:51 essentially. November 18th, we have that entry, right? Yes. And then the next entry related to Mr. Avery is when? 2:44 p.m. Same day? Correct. Made by Corrections Officer Cheryl Mason. Same officer? Correct. And what's that? Says interview with news media done. Started approximately 1400. No reference to asking Mr. Avery about that one. There is no reference to which media it was. No reference to anyone walking a letter back to him. No. No reference to any action at all by you. No. Had you engaged in any action at all on November 18th with respect to the admission of Jennifer Colbus to the jail, would you expect your actions to be reflected on Exhibit 12? Yes. If we assume for a moment that the reporter shows up at the jail unannounced, asks to see you, and hands you a letter to Mr. Avery, and maybe we don't need to assume this, did that happen on at least one occasion? Yes. With whom? I believe it was the interview that we talked about before with Channel 5. The last interview, the December 14th interview, or yes. Or did it happen twice with Channel 5? Could have happened twice. Okay, I'm not trying to trap you on this. Once, twice, it happened. I recall talking to the media quite a bit in our lobby during this time period, and just specifically to name a date and time would be difficult. I agree, and I'm not trying to trap to go there, okay? But you remember at least one occasion, and maybe there were more than one, when Jennifer Cobas in specific gave you a letter and showed up unannounced and gave you a letter and asked you to give it to Mr. Avery? Yes. You did that? Yes. And came back, told Miss Cobas essentially that he will see you. If he agreed to, yes. You recall at least her conducting those two interviews with Mr. Avery? I recall the interviews, as I said, where I stood outside the door. All right, and that interview started within minutes after you handed Mr. Avery the letter from Miss Cobas. Yes. Not time for Eric Lloyd to drive from Sheboygan or Manitowoc or wherever his office is. No. You have, after reviewing the entire inmate file for Mr. Avery, you have no document suggesting that Mr. Avery requested or initiated the November 12, 2005 interview with Emily Matesic. True? True. Those notes were given to Stephen, and I'm not sure what he did with them. Same as to the November 18, 2005 interview with Jennifer Cobas? That's correct. Same with the December 14th, 2005 interview with Jennifer Cobas? Yes. Attorney String, Your Honor, I'm missing a page of the jail log that I had. I wonder whether this would be a good time for a break, and I will get a copy of that page, or I can just take a couple of moments now. The court, no, it's 1. Let's take our lunch break at this time. given the fact that the pace isn't going as quickly as we thought, isn't let's resume at 1:45. Noon recess taken. Attorney Strang, two quick things before we resume with him, Your Honor, if I may. The court, all right. Attorney Strang, one, Mr. Kratz and Mr. Fallon were kind enough to tell me that, at least to them, I left an impression that the Calumet County District Attorney's Office had the entire November 18, 2005 interview, including the raw footage. That wasn't my intended implication at all. The DVD or the CD that was produced is what was aired on TV and nothing more. I intended to, if the court took it that way, I certainly intended no such implication. The court. The only impression I got was that they would have had the telephone interview by the virtue of the fact that it was conducted over the telephone, not Attorney Strang. Right. The court. For any other reason. But I did not get the impression that they had any of the full-length TV interviews. Attorney Strang. Right. I just wanted to make that very clear if it wasn't already. Second, I think Mr. Fallon and I agreed here that it would make sense and be appropriate for the courts to be permitted to take judicial notice of the calendars for 2005 and 2006, so that we don't have to worry about what's a Saturday and what's a Wednesday and that kind of the days of the week, as we're going through these things with witnesses, including on the next motion, I assume. Attorney Fallon. Yeah, I think that's true. I think we can agree, for instance, that the 5th, the 12th, the 19th, the 26th of November were Saturdays. The court. Very well. Attorney Fallon. And we would also just note for the record that a request has been made to corporate counsel in New York for the substance of the entire interview. The initial request was not granted, and we'll see where that takes us, whether or not the results in further hearings elsewhere or not. But at least so the record is clear that a request was made for the entire interview. It has not been adhered to at the moment. Attorney Strang, that not only is that not in dispute, but I have heard that before, from Mr. Fallon. The court. Answer me something here. The motion in this case is a motion to suppress statements made to the media. If the state doesn't have the statements, what's the relevance of other content? Attorney Strang, if the motion is denied for any reason, then we have a doctrine of completeness problem. I'm sure what the counsel has in mind. Attorney Fallon, that's correct, yes, because some of the comments and statements were actually aired. Parts of the interview were aired publicly. The court, okay, and I understand. Attorney Fallon, so either party may choose to use some or of the on-air snippets from the interview. At this particular point, the defense is challenging the three in issue not wanting that to occur, but that's a separate issue on the rule of completeness. And in the interest of accuracy, which was, I think, something that Ms. Kobas was attempting to provide in her testimony, but that's a separate issue over and above the admissibility per se of the statements which were aired publicly. The court, all right. Mr. Strang, you may proceed with your examination of the witness, and Mr. Byrnes, you are still under oath. Mr. Byrnes, yes. Exhibit 15 marked for identification. Direct examination continues by Attorney Strang. Mr. Byrnes, this is Exhibit 15. Do you recognize at least the type of form? Yes. The form is an inmate communication form that we use. Part of the business of the Calumet County Jail is to make regular the communication of inmates to jail staff and jail staff back to the inmates by the use of this form. Correct. It's a standard form that your jail at some time created. Correct. You maintain these in the ordinary course of the business at the Calumet County Jail. Yes. Attorney Strang, move Exhibit 15. Attorney Fallon, no objection. The court, the exhibit is what number? Attorney Strang, 15. Attorney Fallon, we have no objection to the introduction of Exhibit 15. The clerk, I put the wrong number on it. Do you want me to change it to 13? The court, I thought it was 13. The clerk, it should be. I just put the wrong sticker on it. The court, yes, let's make it 13. Attorney String, all right. 13 it is, all right. Exhibit 13, so that's the one I move. The court, there's no objection, as I understand it, from the state. Attorney Fallon, no, it's been renumbered to 13 now. The court, correct. Exhibit 13 is admitted by Attorney String. The top half of Exhibit 13 is on part which the inmate is written. Correct. And then the bottom half is for a response by the jail staff. Correct. The top half is written by Stephen Avery. Yes. The bottom half is written by you. Yes. What's the date of the Stephen Avery's request or his communication? This is January 9th, 2006. And you write back to him on what date? Would have been January 9th, 2006. Same day. Yes. What's Mr. Avery asking? It's addressed to Jail Administrator John Byrnes. It says, I have got TV 26 NBC for an interview on 1/11/06. Aaron Keller, he is going to come and see me. Thank you. And then what's your question or your response to Mr. Avery? My response was, I cannot approve a special visit for this. You will have to do this interview by phone. Okay, thank you. In fact, we'll just leave that there. Now, I think we agree before lunch that Mr. Avery had not made any request for the 3 televised interviews that we have already discussed, but now we have him making a written request for a 4th televised interview. Correct. And although he had not requested for the first 3, you arranged those, and now we have gone through the sequence of your involvement and Sheriff Poggle's involvement and that of corrections officers. This one you're turning down when he finally does request one. May I question you as to why? At some time, I believe it was later in November or December, the sheriff redirected us, I think after speaking with Mr. Avery's counsel, not to grant interviews. It was an agreement that we would abide by the counsel's wish, the attorney's wish, that we stop that process. Eric Loy, at the time, I believe so. Are you aware of any documents reflecting that agreement? I'm sure that Sheriff Poggle issued the memo. I don't have a copy of it. Okay, so you would have received such a memo, some kind of directive from Sheriff Poggle after the 3rd interview and discussed before lunch break, but before this request. So the answer is simply no, even though Mr. Avery is initiating the request. Correct. Sheriff Poggle has not redirected you to prevent telephone interviews with Mr. Avery, correct? There's really no way to prevent it. If the inmate places the call, correct. Right? Yes. Okay. Was there any direction about the request for a telephone interview initiated by a member of the media? I believe that any request, whether it was for a telephone interview or anything, since that it is a change in direction, it has to be addressed to Mr. Avery at the Calumet County Jail. They have to send a letter or not even providing notes to Stephen Avery anymore. Since this December directive from Sheriff Poggle, correct. As to those 3 interviews that did happen on camera, you had an understanding of the topics on which the reporters wish to interview Mr. Avery. True? Not specifically. It was related to the case. Right. Generally, you understood them to be wanting to interview him relating to the case. Correct. By this case, you mean pending charges against Mr. Avery concerning the disappearance and death of Teresa Hobach. Correct. Attorney String, that's all I have. Thank you. The court. All right. Mr. Fallon? Attorney Fallon. Yes, thank you.